Limitation number 1 on promissory estoppel. Existing legal relationship is needed. Let's change the facts of the situation I discussed in the previous lecture. You explain how it's tough being a student, and I promise to pay you £25 to help you along. You finally buy a textbook that you have been wanting to buy but couldn't previously afford. You are under no pre-existing obligation to me, and there is no prior loan agreement between you and me. Is my promise enforceable? There is obviously no consideration for my promise because you have given me nothing in return, and so there is no contractual obligation for me to pay you. My promise was intended to be binding and intended to be acted upon, and you did act upon it. But the courts will still not enforce my promise. This is because the courts can only prevent me from acting inconsistently with a promise to modify or discharge a pre-existing contractual obligation. They cannot make me honor all of my promises by positively enforcing them as though they were contracts. The key point is not that all relied upon promises are enforceable, but that I cannot blow hot and cold, as in the first version of the facts, telling you one minute that the debt is discharged and the next minute that you owe me £100. Sorry, but in the second version, I don't have to pay you £25. The principle of promissory estoppel does not create new causes of action where none existed before. It only prevents a party from insisting on his strict legal rights when it would be unjust to allow him to enforce them. However, this requirement seemed changed in light of the decision in Evendon versus Guilford City 1975. Here the courts held that promissory estoppel can be a cause of action. However, this was overruled by Secretary of State for Employment versus Globe Elastic Thread Company Limited.